Hello, everyone. Welcome to the Arbitration Channel. Today, at Straight to the Point, we're going to discuss international arbitration in aviation disputes. We have a great honor to have here Jonathan Hamilton from White & Case and Gary Bringberg from GEMS. Jonathan, welcome.
Thank you very much. It's great to join the Arbitration Channel for this discussion on international arbitration and the aviation sector. We're going to focus in particular on the new Hague Court of Arbitration for Aviation that just launched in 2022. And it's a pleasure to be joined here by Mr. Gary Bernberg. Gary is an internationally known mediator and arbitrator, but more critically, he's now the chair of the advisory board for the Hague Court for Arbitration in Aviation. Gary, how are you today?
I'm great. Thank you, Jonathan. It's a pleasure to be here with you today. Thank you for the invitation. It's great to be with you and back with Arbitration Channel.
Thanks very much, Gary. Now, Gary, what is it about your background, before we jump into the details here, what is it about your background that is relevant to your new role with the Hague Court for Arbitration in Aviation?
Well, in addition to my legal background, I have a background in consulting, a couple of decades in consulting. And one of the major industries in which I had projects and interventions was, in fact, aviation. So I have a deep experience in the aviation industry from a business point of view. And there's, of course, one aspect that those of you who are watching, who are involved in the aviation industry at all know, once you get a taste of it, it becomes a passion. So you always want to come back to it, work more within it. And this was the opportunity to help to set up and found the Hague Court of Arbitration for Aviation. It was a fantastic opportunity, one that I just jumped on and have happily been running with for the last couple of years since our project started, since we started preparations for our project.
You're exactly right, Gary, about what it's like to work on matters in the aviation sector. It somehow gets into your bloodstream and is a very, very interesting sector. I've had the chance over the entirety of my career with White & Case to work with different parts of the aviation sector: airlines, airports, lessors, lessees, different types of disputes and different fora. Why do you think that dispute resolution and arbitration is particularly important for the aviation sector right now?
That's a great question. Right now, in particular, it's important because it has lagged. The aviation sector has lagged historically in the adoption of alternative dispute resolution procedures. And there's a lot of catching up to do. I can speak a bit to the reasons why I believe it has lagged in the past, but the reality that we're faced with now is that the industry is not taking advantage of ways to resolve its disputes in the most efficient, quickest, and most effective manners, by dint of not having embraced ADR to this point.
Those are great comments, and let's dig in further on that. And let's organize our discussion along three different points. First, why is there a need for a new arbitration center focused on the aviation sector? Then we'll talk about the particulars of the Hague Court for Arbitration in Aviation. And finally, we'll talk about the future of the Hague Court. So let's stick with this issue about why is there a need? And we all know that over the past quarter of a century, really, arbitration has become the go-to method of dispute resolution for most sectors around the world, including not only the private sector, but also in most parts of the world, public sector participation in aviation as well, and across many different industry sectors. But some sectors have lagged, like the banking sector, the aviation sector, Why do you think the aviation sector has lagged in adopting arbitration more broadly?
There are a couple of reasons. The first of them is that one thing that we find frequently within aviation are very particular needs that are not necessarily reflective of the general commercial environment. I always love to bring up the analogy. One thing that's absolutely true in aviation is if there's a piece of equipment, an airplane, which is grounded for one reason or another, for legal, mechanical, regulatory reasons, somebody's losing money. Somebody's losing money. And so it's the capital intensity of the business, the dependency on having a maximum operational realization of that equipment in order to be able to create the revenues that are needed to cover costs and make profits. So there's something a bit particular about the aviation industry. Now, it's lagged. It's lagged to this point in adoption of arbitration and mediation, I believe, for a couple of reasons. One of the most significant of these is over the course of time, there have been some courts that have been set up, most particularly in New York and London, which focus on aviation. And the industry, to a certain extent, and I don't want to say it's across the board, but to a certain extent, became used to using these courts. Indeed, these courts are more efficient because of their focus on aviation than the court process, the litigation process would be. Were players in the aviation industry to go to a more generalized court? But it seemed to lull the industry into a certain complacency in not reaching out and not keeping up with the developments in international arbitration. Now, as you mentioned, Jonathan, international arbitration in particular, but mediation also in a bit of a different application. But arbitration is so important. International arbitration is so important for international commercial disputes because of mechanisms in international arbitration, well, a number of reasons, including mechanisms to guarantee execution of arbitration awards, most particularly the New York Convention of 1958, which has been adopted by 170 some countries. So we don't need to depend on a bilateral treaty or some other treaty among nations in order to in order to execute judgments in litigation, and what's more is also the fact that litigants in aviation, just like in any other industry, don't like to present their case in a foreign jurisdiction. And very often, of course, this becomes the case in litigation. Arbitration gives the ability for litigants, for parties that have a dispute, to mold the contours of the resolution of the dispute. Ergo, they're able to take advantage of, in fact, a semi, if not completely bespoke procedure for their dispute resolution. So I've gone over a couple of the aspects. Shall I hone in on anything else in particular at this point, or shall I keep moving on?
Well, I think those are very important comments, because if you look at the aviation sector, you see that there are areas where the aviation sector has used arbitration, but it tends to be because of its overlap with other issues or other areas. For example, uh, project financing for the construction of a new airport. And take, for example, the new airport in Quito that opened 10 years ago. And that project was a project financing that went through an investment arbitration and also has many different subsidiary agreements where, in my work on that project, we negotiated many different types of arbitration clauses as part of the overall project finance structure and the relationship between the investor, concessionaire, and the state. So there certainly are ways that the aviation sector has relied on arbitration, but it has not penetrated in the way that many other sectors have, like the construction sector, for example, where obviously arbitration pervades that sector worldwide. And it's an irony because arbitration is obviously a highly globalized field of dispute resolution. Aviation is a completely globalized sector, necessarily so for safety reasons. How do you think that this gap can be closed? How do we identify this problem or this gap so that we can then discuss how the new Hague Court might help close it?
Well, that's exactly by having initiatives such as this particular one. I know that many attorneys in the aviation field commented to me while we were doing our research and due diligence on preparation of our court and its rules, that one of their frustrations is when they go to general courts of arbitration, they don't have the understanding of the industry that is needed and its peculiarities or particularities, I should say, and therefore are not properly equipped to give them the tools that they need, or to provide the tools to make their arbitration experience efficient. I'll take a couple of examples. Interim measures are always crucial in, not always, but very often quite crucial in disputes that come up within the aviation field. And if the arbitrators who are handling the case are not knowledgeable about this, if the arbitration institution does not have a culture of informing also the arbitrators about this, then the tools really aren't there, and the arbitrators will be more resistant to use these tools, which really need to be part of the day-to-day toolbox for arbitrators within the aviation industry.
Yeah, you mentioned the expediency of enforcement. If you're dealing with aircraft, for example, that plainly is so critical, because if you have to seize an airport or an airplane, or obtain an order to seize an airplane because of a dispute over control of that asset or payments for that asset, expediency is what it's all about. And I think you made an interesting point, Gary, which is that on the one hand, there are a lot of very established litigation approaches to get quick action in courts for situations like that. But on the flip side, arbitration offers a lot of advantages, because unlike the execution of court judgments, there is, of course, the New York Convention to facilitate enforcement worldwide of arbitration decisions. So with that backdrop, let's turn our focus from the need for a center focused on aviation and to the particulars of the new Hague Court for Arbitration in Aviation. What is this new Hague Court?
It is a specialized court of arbitration and center for mediation, which focuses exclusively on commercial disputes within the aviation industry. And I hesitated a bit before I said commercial, because we don't do everything in the aviation industry. We do not entertain disputes or administer disputes having to do with tort cases, everything from slip and fall to airplane disasters, whatever it might be. But on the other hand, we do reach the full range of aviation business to business questions, be it leasing, sales and resales, equipment, original equipment manufacturers, relationships with airframe manufacturers, MRO, if I didn't mention that before, and airport, airport projects as well. Airport projects and disputes between whatever it might be, airlines and bodies that manage airports and infrastructure. So it's really the broad business to business swath. And what we really are aiming to do is to address the market-based need that we perceived, as we were talking about a moment ago, and provide for the market specialized arbitration and mediation as being a fast, fair, flexible, and final form of dispute resolution. Before, in the case of arbitration, a neutral tribunal, or neutral and impartial mediator as well. In private, which is a great value in many sorts of cases within the industry, and with arbitration and mediation rules and procedures specifically tailored to the unique needs of this unique industry and even of its specific sectors within the industry.
Let's hit a couple of details about the kickoff in 2022. First of all, although based in The Hague, there was a launch event in England. Why don't you tell us about that?
So we had the great honor of having the center stage at the biennial Farnborough International Air Show, Farnborough being just outside of London. One of the, traditionally one of the two big major air shows on the on the calendar within the industry. And we made the splash there simply because the aviation industry was there. It's where everybody goes every other year, and and we wanted to be able to not just be on the big stage, but to be able to talk to people about what we're doing, inform them about the innovations that we've established, and explain why companies should be thinking, companies within the aviation industry should be thinking about depending more and more on arbitration and mediation, and how we can help them to do so and facilitate that process as an administering institution.
What was the reaction on the ground in England when you had the launch event?
It was quite positive. Everybody was curious. We had done our best beforehand to keep our project under wraps. So there were a lot of people who had never, there were some people who had heard of it and knew that it was coming. Many more, I dare say, did not know about it. We received lots of questions, lots of requests for interviews during and after the show. And since Farnborough Air Show, we've been featured in numerous articles, including one published, I know, by White and Case, which I believe, Jonathan, you had a hand in writing. And it was a very good article, by the way.
Thanks very much, Gary. And let's focus on the Hague component. For anyone who's had hearings in The Hague before, especially when the weather is pleasant in The Hague, it's a great place to have a hearing, that's for sure. good restaurants, a traditional place to establish a seat of arbitration. But why The Hague? You could have positioned this center anywhere. Tell us about why this institution is cited in The Hague and what is the relationship with the Netherlands Arbitration Institute.
One of the greatest values that we identified and we wanted to integrate into our structure and our image was openness, neutrality, and accessibility. And we found that the Netherlands in general, and The Hague in particular, provided a venue which reflects a historical openness to trade among foreign countries, as the Netherlands always has been, and also The Hague itself being the city of it's the city of peace and justice, is its motto, and that's reflected by the many courts that are seated there, the many and also a number of treaties in all areas that have been signed there. When people go to a place, when people want to identify a place that they can go where there is a tradition of this openness, of a clarity of that wonderful a Dutch openness and candor, that's the place that they look to immediately. And this was important for us for a couple of reasons. And in fact, I can go into a very short historical explanation, if I might, that we in fact established ourselves some 8 years after the establishment of a similar court for arbitration and aviation that was established in Shanghai, with the assistance, or not with the assistance, but with the full participation of IATA, the big industry association. And we noted that, I don't mean to speak badly of them in any way, but the project does not seem to have really taken off in any significant way. And we went to this court, figuratively, to study what might have gone wrong in this and how we can do this better. And one of the reasons that we felt was there were a number of reasons. The first among them was that China is such a big and important market for aviation. Now, the Netherlands, in contrast, is a small market, yet a market which is very sophisticated in aviation. I don't mean to say that it's more sophisticated than China, but the influence that the locality of the dispute resolution institution, yet which the dispute resolution institution is housed, can color the attitude of the participants. So in the same way that we think that being in Amsterdam and The Hague is better than being in China, so it is better than being in the United States, because the United States would be too big a market. So that's the first thing. The second thing is we wanted to be
effectively. What you're saying is that neutrality, the neutrality of positioning this institution in The Hague can make a critical difference, perhaps, to participation rates over time. Is that where you're headed with this?
Exactly. Neutrality, impartiality, our independence from any industry associations. Another thing which is very important is that unlike the Shanghai court, we are an independent, non-for-profit organization, as a matter of fact. So there are no governments having the capacity, either by perception or by reality, of putting their thumb on the scale of the way that we do business.
What is the structure of the Hague Court? How is it organized, and how is the board that you chair and the others participating in the development of this court taking steps to ensure that the rules of this institution are really focused on the aviation sector in particular, and on listening to stakeholders in the aviation sector to try to maximize the participation in this new institution?
Great. Yeah. So to start out, I want to reiterate what I mentioned before. We're founded on a need-based market proposition and perception. And in order to assure that we responded in both the structure and function of our institution, we went out and we talked to people. We talked and talked. And one of the preliminary things that we asked actors in the industry and lawyers and law firms that represent clients in the industry is, what can we do to preserve this value and maintain this value? And what we ended up doing was to incorporate, in addition to incorporating informally a lot of people in the industry, we formally incorporated a number of people in the industry into various committees and boards that we set up. So in terms of governments, structurally, we have our foundation, which is a non-for-profit. The foundation then is together with the Netherlands Arbitration Institute, which is our administrative partner in this project. Within this structure, we have a board of directors, which is comprised of some 5 people, and also, and they're they're focused on direct oversight, direct management oversight. But we also put together a board of advisors, which indeed is the board that I'm privileged, or one of the boards I'm privileged to share within the within our organization. And within this board of advisors, in contrast to the board of directors, which has a very few number of people, we wanted to gather a fulsome participation in this board. So at this point, we have over 40 members of the board of advisors, and they come from every part of the aviation dispute resolution world. In other words, we have attorneys who work within aviation. We have arbitrators. We have mediators and university professors in arbitration and in arbitration and mediation who are thought leaders on structuring dispute resolution services. We have executives of aviation companies, again, across the board, and retired executives as well. It's a great swath of the industry. It's our internal think tank in a way, and it's set up to be that brain trust that we can go to and talk about basic strategic principles, how we can better respond and provide structures that are suited to the aviation industry. And then in addition to that, we have 2 other standing committees at this point. We have a technical standing committee, which is what you might guess. It's stacked with technical people who know the technical aspects of arbitration and mediation and the aviation industry, who are able to give direct feedback as to how we can create hypercharged processes which will robustly reflect the needs of disputants. And we also have a standing rules committee, which I'm also privileged to chair, and to have Jonathan's participation as in fact, one of the leaders, internal leaders of the standing rules committee. So within the Standing Rules Committee, to drill down a bit more to your question, Jonathan, we are looking, and will continue to look at modifying at creating a bespoke set of rules for arbitration and for mediation. Of course, arbitration rules are more important than mediation rules in their detail, because the arbitration is much more of a prescribed and closed process than the open process of mediation. But the arbitration rules are being drafted or redrafted at this point, as a matter of fact. And over the course of time, they will be constantly reviewed and, to the extent needed, revised by the Standing Rules Committee. In addition to that, if I may, forgive me if I'm droning on too long on this point, we are in the course of publishing what we expect to be a great number of alternative dispute resolution clauses that will use our arbitration rules as the jumping board, as the platform to go further and provide clauses which attorneys can then take off the shelf, perhaps make some minor adjustments to them, but they take off the shelf from any number of shelves, depending on the exact type of conflict that their clients might confront in a potential dispute. So we would divide them by sectors and by nature of dispute within the sectors as well. But the interesting thing is, we've loaded, and we plan to load, these clauses with all of the fine points that can help to streamline these procedures in a way bespoke to the very needs and the micro needs of aviation, of parties within the aviation sector.
So Gary, we've covered so far two of our three topics. First, we spoke about why there's a need for a new institution focused on arbitration in the aviation sector, and how this sector in particular has a gap in the dependence on arbitration. Second, you covered a lot of interesting details about the new Hague Court for arbitration in aviation, and how it really has been built from the ground up with the right kind of stakeholder participation from the business side, the technical side, the legal community, academic community, to try to find ways to close that gap. Third item, let's look into the future. So the institution is really just launched. If we look 5-10 years into the future, where will this institution be a little bit further down the road? And what are some of the concrete steps that it will take to drive adoption of its rules, which is ultimately what has to happen? In other words, you need to get more Hague Court of Arbitration for Aviation clauses into more contracts with more stakeholders in order to drive the continued growth and development. So how do you see that playing out in the future?
There are a number of ways that this will play out in vehicles that we currently and in the future plan to use in order to drive that. One such vehicle is doing just what we're doing here today, and which I do, as I thanked you before, I'm going to thank you again, Jonathan, for inviting me to this conversation, and to also reflect some of the experiences that you've had in aviation with our court, with our nascent court as well, and cover the dynamic and the advantages that we're moving into. One of the things that we do plan to do in addition to this, and in addition to the typical road shows to go out and speak to players in the industry, both legal and pure aviation, is to be a convener convener of the industry. We like to consider ourselves, and we would like to be able to consider ourselves in the future to be the prime convener of for legal conflicts and legal matters within the aviation industry. One of the hopes that we have is to establish a yearly conference, which we expectedly would hold in The Hague, well, at least on our first time, in which we would bring together the various players in the industry, if we've brought them together within our umbrella of boards, etc., and committees within the court, but to invite a broader swath and to really get great participation within the industry, where we can speak about the key issues, in which we can reveal developments and be a platform for disseminating information, and again, and to challenge the participants to help us and help themselves as well, to help us develop our toolkit and better refine our skills and our procedures as an administrative institution and as the home of some great arbitrators and mediators, whom, by the way, for whom, by the way, and here's another step, we plan to offer training in arbitration and mediation within aviation. We already are working with a lot of great aviation, or a lot of great international arbitrators in particular, as well as mediators. But as I intimated beforehand, in terms of the struggles with the aviation community in the lack of consciousness of many professional dispute resolution professionals about the needs of the aviation industry, we want to be there for training as a resource bank, and as I mentioned before in another context, a brain trust that people internal to us and external to us can come to learn more about dispute resolution and effective dispute resolution and its needs within the aviation industry.
What do you think is your best chance to drive adoption of arbitration clause referring disputes to the Hague Court? Is it going after the companies or going after their lawyers?
Well, I'm going to give you a typical lawyer's response to that. The response to one or the other is yes. In effect, I think both are very important, and that's simply knowing the structure of how companies typically do their dispute resolution. Often, very often, the impetus to make some sort of change comes from the trusted advisor, the attorney, who goes to the client and says, look, there's this new court out there. We really ought to be taking advantage of it because it will streamline, might make more effective. It'll make life easier and better for us when it comes to a dispute. But by the same measure, we plan to go directly to these clients and say, this is what we have to offer. These are the business advantages that it will offer to you, including shorter lag time between the initiation of a dispute and a resolution of the dispute, which can have strategic implications for the aviation world. And just to pull one example out of the air, in the middle of a dispute in aviation, as in any industry in which there's a high cost of, or rather there's an intensive capital investment. One of the companies, a respondent, might need to sequester funds in the case that they and take them out of working capital in order to make a provision for a potential negative judgment against them. So the less time that these funds are sequestered, and which we would accomplish through the efficiency of our court, the less time cost of money that will be surrendered by these companies. So this is what we'll do. And we go to the law firms, aviation attorneys, and talk about the legal advantages, ask them to speak about that to their clients and to write us into their clauses. But that doesn't preclude our going as well directly to the aviation companies, both their legal departments and perhaps their executive, their business offices, operations offices, and saying, this is how we can perhaps improve your bottom line, or at least eliminate a drag on your working capital and the attention that you might need to divert from strategic necessities to legal challenges.
I think we can sum it up by saying that there is a truly globalized industry sector, aviation, the leading global dispute resolution mechanism, arbitration, and now a new institution aimed at putting the two together based in a beautiful city in Europe. It sounds like all the ingredients for a success. So I will say thank you to you, Gary Bernberg, for joining us for this discussion. Thank you to the Arbitration Channel, and to you, Gary, and to all our viewers. Look forward to seeing you in The Hague for aviation arbitration in the future. Thank you very much, Gary.
Thank you, Jonathan. Thank you as well to Arbitration Channel, and thank you to the viewers of this cast. Do not hesitate to get in touch with us at the Hague Court of Arbitration for Aviation if you have any questions. Be happy to serve you in the future.
Thank you.